a call to action, and I briefly just kind of wanted to go over some of the reasons why we have selected that as a theme. Before I do that, I do have a little bit of housekeeping. There is going to be a list being passed around the room. It's for sign up, and if you are already an accredited attorney with the VA, please indicate that. The Veterans Clinic has turned away 20 since the start of the school year? 25. 25 or so since August 22nd. That's just the last couple of months. There is a very, very large need for this service. The programs, as great as they are that are out there, are overwhelmed, and they are in need of assistance from this community. So please do indicate if you are accredited. And when you do get to be accredited, because I'm sure all of you want to do that.
Sorry, sir. Can't hear you very well.
Can't hear me? Okay. I don't like these things. Okay. So sheet going around, if you're accredited, please sign. That was the gist of it. That is so we can have a referral list for the clinic for just the sheer numbers they have. They're not able to service everybody. Okay. The reason this has been titled a call to action has that as evidence of there is a tremendous unmet need amongst veterans that are going through the VA process right now. To a large extent, this has left this was in the national news a few years back. It has mostly left. And the reason behind that is that the VA has made tremendous progress in working on the backlog. Back in 2012, they had nearly 900,000 claims in backlog, and the most recent report they have is under 400,000. So they have made tremendous progress, but that's still nearly 400,000 people that are in this process. They're in the process less time, but they are still in that process. And that entire time that the backlog has been being worked through, for those attorneys in the room, the number of appeals has been going up. In that same time period, the number of veterans in appeals have gone up nearly 100,000. That is an area we as attorneys are especially suited to assist clients, yet the vast majority are going unrepresented. That is something we are in a position to help. In the last fiscal year, the VA processed nearly 1.4 million claims. Just to give everybody a little bit of a point of reference, Social Security Administration processed 2.5 million disability claims. Yet we do not have 50% of the lawyers. You can throw a rock in any random direction and hit a Social Security disability lawyer, but you don't hear anything about VA lawyers. We don't have 50% of the CLE programs that SSD lawyers have. We don't have the advertising, we don't have the space. The training programs that are available certainly don't match that number. So it is upon us, those that have come today and have shown this level of caring for these people that are going unserved, these veterans that have served all of us, to go out there and change that. And we would call upon you to assist veterans to take these cases, not just through the clinic, but also out there in the community, to make it known that you are willing and able to assist these veterans. But to also talk to your bar associations. This is not even a hardly recognized area of practice in many bar associations. When you talk to many local bar associations, they don't have any idea that such programs exist or should exist. And we need to change that if this is ever going to be a thing that is ever handled anything like the service that you get for such things as Social Security disability. Earlier today, I believe it was Professor Abrams talked about cross-pollination between the various communities. And today is a great example of that, and it's something we really should all be more aware of. At times, the relationship between the VA and the attorneys, bars, associations, and the veteran service organizations has been not always particularly all that friendly. They're not inclined to necessarily help each other. But we all have something we can offer the other. And if we are to serve this very, very large body of people that need this assistance, we need to all be working together. And this is this event where we have representatives from the various veterans attorney associations. We have representatives from the VA here. We have representatives from the service organizations. We have members of the medical community. This kind of event should serve as a model for that type of cooperation. I'm going to give you a brief introduction to our speakers this afternoon, besides myself, obviously. And then I will turn the floor over. Our first speaker is going to be Professor Drake. She is the director of the Veterans Clinic here at the university and has put this event on, and it has been fantastic already. For those of you that were here for the morning session, you know that. Prior to joining the university, Professor Drake practiced complex and class action litigation, as well as insurance coverage and defense. She was a member of Newald, Waldeck, and Brown in Kansas City, and then Lowther Johnson LLC in Springfield. And at the university here, she teaches insurance law, pretrial litigation, and trial practice. We're there going to hear from Amelia Tapp, who is a decision review officer at the St. Louis VA Regional Office. She has literally a lifetime of service to veterans. She was a frequent volunteer for the Disabled American Veterans, DAV, in her childhood. And then has moved into a career with the VA. She's worked at both the Chicago and St. Louis VA regional offices. And she specializes in military sexual trauma cases, PTSD, traumatic brain injury, neurological disabilities, and working cases involving former prisoners of war. She'll be followed by David Myers, who is the Director of Case Evaluation and Placement of the Veterans Consortium Pro Bono Program. And he was a commander in the U.S. Navy, so we have a veteran amongst us as well up here in the speaker's podium. He served on the USS Ranger, 1973-1974, Southeast Asia. He, while in the military, served as the Director for Special Programs Division of the Office of the Judge Advocate General, various other programs as well. And finally, we will hear from Amy Odom, who is the Director of Litigation for the National Veterans Legal Services Program, where she has represented veterans and survivors before the U.S. Court of Appeals for Veterans Claims, as well as other federal courts. She also trains and develops not only the staff attorneys for the NVLSP, but also the attorneys that go through the Veterans Consortium Pro Bono program. So she's responsible for a lot of the training that happens in this community. And she also has contributed numerous bits to the publication, such as the Veterans Benefits Manual, which is kind of the Bible on these programs out there. And with that, I will turn it over to Professor Drake.
Thanks, Tom. Tom's modest because the reason we're doing this CLE is because after the symposium last year, Tom cornered Amy Odom and said we need to do a lawyer training. And then Dave Myers and I and Amy talked further, and we had 77 people registered for today, so we're delighted that there's such an interest. And selfishly, I will tell you what Tom said about our clinic declining over 20 clients since August 22nd, which was the first day of the semester, is true. And it's sad, and we don't like to tell veterans no. And when we tell veterans no, we really, really like to send them somewhere else. And we do send them to the veteran service organizations. We send them to a few lawyers in Kansas City who have been trained. But I'm worried that we're going to wear out the welcome mat. And lawyers as a group are particularly well trained to help a veteran at the earliest possible stage. Tom talked about the appeals process and how many veterans are unrepresented on appeal. If we can get in there even at the regional office level and get the evidence developed and get it packaged up appropriately and show the adjudicator how to grant the benefit, we can do our part in helping VA reduce the backlog. So I appreciate everybody being here, and there will be a sheet circulating where you can indicate if you want to take a case and where you practice and where your interest lies, so please sign that up. I'm talking really fast because I want to get through sort of the ABCs of disability law and touch on pensions and survivor benefits, so we set the stage for Amelia Tapp from the St. Louis office and David and Amy. So I'm going to give you the highest level overview of very basic benefits law, and I know there's some people in here who have done this work before. This may be a little boring, but I know there's some people in this room who have never done this before, and they need to hear the very elementary principles. So we're going to cover the Department of Veterans Affairs, basic eligibility, service-connected disability benefits, ratings. You heard a little bit about this morning. Pension. I need to cover pension and survivor benefits with you so that you can claim this as your 3-hour CLE with VA, which we're going to talk about later. And then later, after I talk, you'll hear about how to apply with VA at the regional office. Amelia is going to tell you about the new fully developed claim program. Dave will tell you about the Board of Veterans Appeals and the Court of Appeals, and Amy will tell you what to argue when you get there. So it's going to be a packed 3 hours. First, though, for the new people in the room who haven't done this work before, please know you will not be going to your local circuit court. You're not going to go to Boone County. You're not going to go to Jackson County. You're not going to go to any federal court in the Western District of Missouri. Your world, when you help a veteran, is in the system known as the VA Regional Office, is where you file a claim. If you don't like that, you go to the Board of Veterans Appeals, which is in DC. If you don't like that, you go to the U.S. Court of Appeals for Veterans Claims, to the Federal Circuit, to the Supreme Court. So you're not running to your local courthouse, federal or state. You are within this triangle. Cases go up the triangle and they also come back down the triangle, and we'll talk a little bit about that later as well. So that's the world within which you live. And the way to get into the world is you have to be accredited. So VA loves forms. Lawyers need to file Form 21A. And think of this as your character and fitness that you did to get into the Missouri bar. You had to say where you lived the past 10 years and whether you have any felonies and all those personal questions. This is a lot like that. You have to let VA know that you're in good standing, give them your addresses, fill out their form, and then you wait for them to tell you that you are accredited. This takes anywhere from 30 to 120 days. Mine came within 30. Sean, how long did you wait? You did it most recently.
I think mine was somewhere around
3 months, yeah. So give it time, but get it done, because you cannot represent a veteran unless you are accredited. I'll say it one more time, because I get a lot of lawyers who call me and they want to help, and that's awesome, but you cannot represent a veteran if you are not accredited. So please get accredited. Once accredited, then you have to get your 3 hours of CLE sometime within the year of your accreditation. And that CLE must include disability compensation, pension, and survivor benefits. So let's talk about who you are dealing with. You're dealing with the Department of Veterans Affairs. Their mission, they are non-adversarial. I need to say that again, because for a lot of litigators in the room, we're used to the adversarial process. This is a non-adversarial process by statute. Okay? VA is supposed to help families with dignity and compassion and be their principal advocate. People laugh because veterans often are frustrated, but somebody said it earlier. It was Amy Odom. The lawyers sometimes see the bad cases that didn't work out. There's lots of times VA gets it right. Okay? There are lots and lots of times where they get it right. And they get it right because this is their mission. So for you litigators out there, this is non-adversarial. Don't make it adversarial. Don't feel like you have to be the jerk when you're dealing with VA. Everybody is trying to get to the same point, and that is helping the veteran. And if you show them how to help the veteran, they're going to follow you. So it's non-adversarial. And here's another thing for litigators in the room. VA has a duty to assist. So they're supposed to help you with evidence development. Sometimes you have to remind them of that. All of that being said, go ahead and develop the evidence on your own, because we're lawyers, right? We're lawyers. We know how to collect evidence. We know how to put it in chronological order. We know how to make it look good. We know how to connect the dots. Go ahead and do that. But that's the world that you're living in. VA is a bureaucracy. It's the second largest federal department, 150 with $1 billion as a budget. Half of it goes to disability claims. The remainder is for health care. They have a central office, sort of the hub of the wheel is in DC, the VA central office. They have 3 branches. Amy touched on it this morning, the Veterans Health Administration, that's where health care is provided. Veterans Benefits Administration, which is where you go for disability compensation, or the National Cemetery Association. So you have a veteran, and your veteran is disabled, and your veteran wants compensation. Couple things you got to get through right away. Who is a veteran? They have to be a veteran. They have to, and this is all statutory regulatory land. Here are the statutes and the regs. It's all in 38 USC, one chapter of the code. All the regs are in 38 CFR. You need to get this, and you need to get the Veterans Benefits Manual. This is what we call the Bible. This is not the newest edition because the newest edition is missing in action in the law school. It happens all the time. We use it all the time. It's a really good book. You need to have this. In there you will learn veterans are those who served in active military, naval, or air, and who were discharged or released therefrom under conditions other than dishonorable. Other than dishonorable. Those are very important words. That's called the character of discharge. In order to satisfy the definition of a veteran, the individual must have been discharged or released from service under conditions less than dishonorable. That sounds easy enough, but when you get your veterans DD 214, which is their separation document, and you look at the line on the bottom to see what the character of discharge was, it's not going to use the same words as the regulations. It might say under general conditions or other than honorable. It's not going to fit nicely in here, and you need to understand that even if the DD 214 doesn't say honorable, that doesn't mean your veteran cannot get benefits, okay? Even if it's other than honorable, I need to say that again because these words sound so similar. Even if it's other than honorable, it's not dishonorable. Think about that. Write it on a piece of paper, put it under your pillow. Other than honorable is not the same as dishonorable, and there's other language that they use. But my point is, the veteran can still get disability benefits by going through what's called a character of discharge review with VA. It's 38 CFR 3.12. And this is an education thing with your veteran because a lot of veterans will say, oh, my DD 214 says other than honorable, I can't get anything. That's not necessarily true. Stacy Nix, one of our students, was successful in having one of our clients receive benefits because we presented evidence that his other than honorable discharge was an exception and that VA should provide him benefits and compensation, and they did. So again, 38 CFR 3.12 is what you want to use in that context. And you need to remember that a character of discharge review for disability benefits is different than a discharge upgrade for a veteran. If you have a veteran who has an other than honorable, you can go have their military records corrected with the appropriate branch of service, and they actually changed the DD 214, and that's called a discharge upgrade. That has nothing to do with getting compensation and benefits. Other than honorable, if you want compensation and benefits, you do 38 CFR 3.12. That's an administrative proceeding. You're not talking to the particular branch of service to change the paper of the DD 214. So all of this will make sense to you after you start working with a veteran and looking at their DD 214. And if anybody ever has a question on their files, please call the clinic and we'll try to help you to the extent that we can. And if we don't know the answer, we'll call Amy Odom and she will know the answer and we'll get it to you. So the veteran, also to be a veteran entitled to compensation, must have active service requirements. Active service includes active duty. That's obvious, but it also includes training, and we hear this example all the time. If your veteran was at basic training playing softball with his buddies and twisted his ankle, guess what? That still counts for compensation. You don't have to be in the war zone to be able to collect disability benefits. If you have an injury that was incurred or aggravated while in service, anytime from a temporal standpoint, from the moment you entered service until you were discharged, even if you were playing softball, and you're disabled because of that, you are entitled to benefits. And Reserve and National Guard are also entitled to benefits when they are called to serve on federal active duty. It's very important for you to understand whether or not your veteran served in wartime or peacetime, because wartime veterans have special regulations which apply to them, and sometimes the burdens of proof are easier for veterans who served during wartime. So you need to understand what the wartime periods were and figure out if your veteran served during that time period. And please note that with respect to number 4, we're still in a wartime period because the Gulf War has not concluded yet. So you cannot get any disability benefits if you're veteran engaged in willful misconduct. That's deliberate or intentional wrongdoing. Okay. If your veteran goes and murders somebody and then claims post-traumatic stress disorder because of the murder, they murdered somebody while in service, they're probably not going to get any benefits because that's willful misconduct. It's a bar to any benefits. These are examples of what is and is not willful misconduct, and we're going to put our PowerPoints up on the website for future reference if anybody wants them. Alcohol is willful misconduct. Drug abuse is willful misconduct. Venereal disease is not. Okay, because VA doesn't want to really, I don't think they want to get into how and when the venereal disease came up, so it's not. Suicide, this is interesting, is not willful misconduct as long as the deceased veteran was of unsound mind at the time of the suicide. Note, this is all regulatory, okay? This isn't case law. This is in the regulations. And the regulations are pretty much this specific. I mean, it's a whole different world for those of you who haven't done Social Security work or work comp. This is a whole different beast of law. So how do you establish the benefits? 3 elements. If your veteran wants disability compensation, there has to be a current disability. There has to be medical or lay evidence of something that happened to them while they were in service. And then you have to have the nexus, think torts, proximate cause. You have to have something tying the current disability to whatever happened in service. Usually that's a medical opinion, but not always. So this is easy stuff. This is what we lawyers are used to. 3 elements to prove a claim, right? Current disability, something happened in service, and there's a link between the 2. And then drilling down on that a little bit more, there's 5 ways to prove the link. And there's lots of detail in the Bible about these 5 ways, but as an overview, there's direct service connection. If your veteran currently has bad knees and the veteran was a paratrooper like my dad, there's probably direct service connection there, right? He landed on his legs, his knees are bad now. Another way to service connect a current disability is through aggravation. If your veteran came into service with a bad knee and it got worse during service and basic training, that's called aggravation, and you can service connect the current bad knee to service. The third way is presumptive, and this comes from the statutes and regulation. This is Agent Orange, herbicides, Gulf War syndrome. There are certain things that are presumptively tied, and you don't have to get the medical opinion. If you have a Vietnam veteran who served boots on the ground in Vietnam and currently has a disability on the list of presumptive diseases, which is a very long list, from diabetes to ischemic heart disease, you don't have to have a medical opinion linking the 2. The other way to tie a current disability to in-service is secondary service connection. For example, your veteran comes to you and said, I really hurt my left knee in service when we were playing softball in training. Since I got out of service, I use my right leg a lot more, and now the right knee is blown because the left knee had been blown. That's called a secondary service connection, and you can get compensation for the right knee because it's related to the left knee going out. And then the last way to establish service connection, the nexus requirement, is with VA malpractice. If there is malpractice by a VA health facility or physician or nurse, it's like a malpractice case, you prove it, and they get a disability payment because of it. That is distinct from the Federal Tort Claims Act, completely distinct, unrelated. You can pursue both. For VA disability compensation purposes, there are no statute of limitations or notice provisions like you have with the FTCA. But you also don't get as much money because you're limited to the rating schedule, depending on the case. So what's the evidentiary requirement? This is huge also for those of you who practice general litigation. Usually we have the preponderance of the evidence or clear and convincing evidence. In VA land, when you're in the triangle with the veteran, it's as likely as not. It's awesome. It's awesome. I mean, it's like when the evidence, and the cases say this, when the evidence is in equipoise, what a great word, equipoise, when it's as likely as not, the benefit of the doubt goes to the veteran. And you will see lots of statements about that, and we remind VA of that quite a bit. So that's a very veteran-friendly evidentiary standard. So once service connection is established, VA then assigns a disability rating, and this gets looking a lot like work comp. Okay, they find a diagnostic code that matches up with the injury, and they read a chart, and they give a percentage, and then the percentage gets tied to the current regulation on what that is worth. So, for example, this is what it looks like for amputations. You get 40% if you have a thumb amputation at the metacarpal resection, and the 40-30 is depending on which hand is dominant. But I mean, it's regulations. It's very cut and dry. This is what it is. So, the other thing you need to think about is VA math is not regular math, and veterans usually have more than one disability. So say you've got a thumb, a knee, and a hearing issue. Not unusual. And it matches up to 70, 30, 20 for the veteran. That doesn't equal 120% in VA math. They have a combined rating. There's a schedule in the book that shows you how to get there. You can do the math. But they round up to the nearest whole number, and that is the percentage that is applied to your veteran, and that is the amount of money that they get. So currently, just to give you an idea, a 10% rating right now is $133 a month. The veteran doesn't have dependents. If the veteran has dependents, it gets adjusted. A 100% rating is $2,907 a month. So you can see the swing. Disability compensation is not taxable, very important, and generally it is not subject to garnishment. So one thing there's like 100 different ways we can go, but you will hear, if you do this work, about total disability based on individual unemployability. And that is, a veteran can get to 100% even if their disability is not rated at 100% if they are unemployable. Like Social Security, kind of. But VA follows its own regulations on this. So just because your veteran does get SSDI doesn't necessarily mean that they're going to get VA individual unemployability. In order to get VA unemployability, the veteran cannot be engaged in and must be unable to engage in substantially gainful employment, and there's a definition for that in the regulation. And the veteran has to meet certain scheduler requirements, including one service-connected disability rated at above 60, or 2 or more disabilities, one of which is at 40, and the combined rating is 70. Again, I know this is sort of, eyes may be glazing over, it's all in the regulations, but you need to familiarize yourself with TDIU, or individual unemployability, because it comes up a lot. So, you need to know also that VA has discretion to reduce or increase the disability percentage. They can reevaluate, they can reexamine. You need to always tell your veteran to show up for C&P exams and prepare them for the C&P exam. Help them understand what is going on. In addition to ratings, there are things called special monthly compensation. So in addition to that 100% you saw for $2,900 a month, a veteran can get additional compensation, and it's all in the regulations. But for example, if the veteran has lost a creative organ, that's $100 a month. If they are housebound, they get an additional amount of money of $3,152. Aid and attendance, if they need somebody to help take care of them, that is an additional payment as well. So again, I know this is a lot of information, especially for new lawyers. What I want you to understand here is you can get over the 100% if you look at special monthly compensation, which applies usually with loss of creative organs, housebound, aid and attendance. Again, it's all in the regulations and in the Bible. So, very briefly, pension. Veterans are entitled to pension only where they have wartime service and permanent and total disability. But if they're 65 or older, they're presumed to have permanent and total disability, or if they're in a nursing home, or if they're receiving SSDI or SSI, and they have need. Pension is a need-based program with VA. Okay, veterans don't just get it. They have to have financial need. In contrast, disability compensation, veterans get disability payments. They can be millionaires. They can have just won the lottery. It doesn't matter when it comes to disability compensation. But for pension, they must have financial need. And VA will actually look at their income. That includes their spouse's income. Periods of war, again, you need to know the periods of war. Comes up again. And I went through that. I'm going to move through these pretty quick. 3 different pension programs. Again, all based on disability and need. Improved pension is one program that we are working under now, and it only applies after 1979. There's a Section 306 pension, which applies from 1960 to 1978, and the old pension law, which is before that, where spousal income was not included. But now, anything after 1979, they are going to look at spousal income. The way VA does it is they have a maximum allowable pension rate, and then they ask the veteran for financial information. And if the veteran says, let's say the maximum allowable pension rate is $10,000, I think it's actually around $18,000. It's $18,000. And the veteran reports, I make $10,000 a year, and that includes my wife or spouse's salary. VA will say 18,000 minus 10 equals 8, we pay you 8. That's how it works, and it's based on the income that the veteran reports. There's lots of exclusions and deductions in that equation that you need to understand if you help a veteran with pension. Again, all in the Bible. There's a special monthly pension benefit awarded for disability levels that exceed permanent and total, for housebound and aid and attendance. So, for example, you may have a veteran who is rated at 100%, because that's 100% is all you can get, but actually when you total up all their disabilities, they're at the 120 or the 150. although they're only paid on 100, they may be entitled to the special monthly pension if they are housebound or if they require help from somebody at home. And again, VA requires income verification reports, eligibility verification reports, which are due every year. And if you fail to report income, VA will come and ask you to pay them back, not surprisingly. There are ways to dispute a debt, and you can and the veteran can also request a waiver and show hardship. So moving on to survivor benefits. This is when, and it happens, it's happened in our clinic, your veteran will die during the pendency of their appeal, literally. And then what happens? The spouse can step into the shoes of the veteran. It's called an accrued benefits claim, or you substitute the spouse in. They're slightly different, but the same idea. The spouse literally steps into the shoes of that pending claim that the veteran had, and the spouse is entitled to any money that VA would have owed the veteran. So, for example, we have a claim in Phoenix. It's a Vietnam veteran who had lung cancer. He had a VA claim pending at the time of his death for his lung cancer. He died before the claim got adjudicated. Lung cancer is on the list of Agent Orange diseases. He was boots on the ground Vietnam vet. VA will pay him at some point, but he died while he was waiting. Wife is entitled to step into his shoes, and she will receive the amount of money that VA should have paid him because his claim was pending at the time of his death. That's accrued benefit substitution for the spouse. In addition, the spouse is also entitled to dependency and indemnity compensation because her husband died of a service-connected disability. So she will get around $1,200 a month, $1,500 a month as a DIC payment. So she's gonna get whatever money VA owed him up until the time of his death as an accrued benefit claim. Then she gets from the time of his death until her death or remarriage, a DIC payment because he died of a service-connected disability. Again, I know this is overwhelming, and I'm just trying to give you the big, right things to be thinking about when you have a veteran or their spouse come in. And the spouse may also be entitled to death pension, which is related to financial need as well. I'm out of time, and I really want to make sure that you hear from Amelia Tapp, who will tell you more about how to do a claim, and we're delighted that we have somebody from the St. Louis Regional Office here. So I'm going to turn it over to Amelia, and she'll talk for 45 minutes, and then we'll take a break.
45 minutes, that sounds scary.
Well, you don't have to go that long. There's nothing wrong with being early.
Not for me, scary for you all to have to stand there and listen to me for 45 minutes. Thank you. Thank you. I have a confession to make. I hate microphones. I feel like I need to break out into Irish drinking songs when I have a mic in my hand, but I won't do that. This is probably the first presentation that I've given on VA benefits with the smell of barbecue wafting through the air, and it's great. It's great. So I love it. I'm coming back. On behalf of the St. Louis Regional Office, my employer, the St. Louis VBA Regional Office, I'd like to thank Professor Drake and the Veterans Clinic and the Mizzou Law School for inviting us. Thank you for having us here. Thank you for reaching out. And hopefully this is the start of a great collaboration between us at the regional office level and not just the law school and the Veterans Clinic, but all of the lawyers and the advocates that you all reach as well. And that's everybody here today. So thank you all for being here. Thank you for being willing to help veterans. Thank you for being willing to learn. The regional office needs you. The regional office needs our veterans advocates. We're all on the same team. I love the statement Professor Drake made where we are at the VA, we are non-adversarial. It is our job to grant every benefit we can. It's written in the regulation. Personally, I love signing those decisions where I know that the checks are being sent. I have a wall of fame where when I need some motivation, I'll go back and I'll look and I'll say, oh yeah, I remember that veteran. That veteran had a $250,000 retroactive payment. You know, that's what we do at the regional office. We grant when we can and only deny when we absolutely have to. That said, there are a lot of times we want to grant these benefits that Professor Drake just went through. There are a lot of times that we want to grant these benefits and give this money away, and we just can't. The evidence isn't there, or the records from service are not there, or we are missing one key element. That is one of the areas where you all, as representatives, come into play. You can help us put that case together. You can help us build that case in order for us to grant those benefits that we so desperately want to grant for our veterans. You know, we're all here to serve. And I love that this is Veterans Day, and this is what we're doing today, is talking about this. So as advocates, we're on the same team. And for us, Tom talked about the backlog a little bit with the VA. He was going over some of the numbers in his presentation a little bit earlier. We are backlogged. We're working at the VA. We're working to resolve that. We're working to process these claims much more quickly and as best as we possibly can. That said, it helps us when we receive a claim that's all wrapped up into a nice, tidy little bow that we can look at and say, wow, everything is here. Everything I need is here. That isn't always the case, and that's understandable, and it is our job, it's our duty to assist, to help veterans and their advocates obtain all of the information and develop these claims. But with the advent of the program that Professor Drake asked me to speak about, we are now accepting, and have been since, I think 2010 was when the pilot started, 2010, 2011, we started accepting fully developed claims. This is a specific type of claim where the veteran and the advocate work together, or the veteran on his or her own, prepares a claim in its entirety and submits it to us with everything that is there. Private treatment records, evidence of a current disability. Sometimes they give us the link to service. As Professor Drake said, maybe it was Amy Odom earlier, I think they both touched on the fact that there are 3 elements to every claim: a current disability, an in-service event, and a link between the two. And with these fully developed claims, the veterans and the advocates are giving us everything we need in order to adjudicate and hopefully grant that claim. Now, if something is missing, and we'll go through this, we as VA will still obtain it. For instance, the link, the nexus in between. A lot of times it's difficult for an attorney or a veteran's advocate and a veteran to obtain a medical opinion or to obtain a link between the current disability and service. VA will still obtain that and will still leave the veteran in this program. So we're going to talk about this fully developed claim program a little bit, and I know that you all will probably have a lot of questions for me as the VA person. You probably have a lot of questions about this program, but we're saving questions until the end, so ignore my giant question marks in this program, please. But I'm here to help you all. I'm here to help you all help veterans. The more of these little tentacles we have reaching out into the veterans world, the more we can help who we're here to serve. So let's talk about the FDC program a little bit. Okay, thank you. We're going to, yes ma'am, thanks. We are going to, in general, talk about some of the easy forms, parts of the forms, the various forms you need to file some of these fully developed claims, incomplete claims, exclusions from this program, the development, retroactive effective dates. It's kind of a laundry list of things that we'll cover. So This program, the Fully Developed Claim Program, is not the only way for a veteran or a claimant to file a claim. There is another way, and it's just a standard application procedure. But we're going to stay with the FDC for now, and if you have any questions later, I'm here all night, as long as you all need me, if anybody wants to stick around even after the official program. But the types of the new forms on this Fully Developed Claim Program are what we call the EZ forms, and that's exactly what they're supposed to be. They're supposed to be easy. So they started calling them the EZ forms. The 21-526 EZ is for the compensation benefits, current service-connected disability, caused by service, compensation benefits. The 21-527 EZ is for the non-service-connected pension. That was one of the last things Professor Drake mentioned, the income-based benefit for wartime veterans. And then the last form is the 21-534 EZ, which is for, I can't stand there because I'm casting a shadow, which is for the dependency, indemnity compensation, death pension, accrued benefits. The 534 EZ is for the survivors, the various benefits that a survivor of a veteran can apply for. In order to be eligible for the FDC program, the application must be filed on an EZ form. If the veteran requests some sort of processing but did not file the claim on an EZ form, the veteran will automatically be excluded from the FDC program and put through the traditional application program. The newest forms are from August 2013. We are accepting those into the FDC program. Forms prior to August 2013, EZ forms prior to August 2013, we'll still accept them as claims for benefits, but they'll have to be excluded from the FDC program because of the date on the form. So when you're considering filing these fully developed claims, and you have a stack of forms next to you, take a look at the date on it. Your best bet would be to go to the VA website and obtain the newest copies of these forms. The Fully Developed Claim Program, in addition to helping us expedite claims because everything is submitted at once, also started providing the veteran with all of their due process rights and their duty to assist notification, what we call the VCAA, Veterans Claims Assistance Act, or 5103 notification. These forms also provide veterans with all of that information up front. Prior to the advent of the Fully Developed Claim Program, we would receive a claim from a veteran, and we would be required to send him or her a letter or notification listing all of their rights and listing what we do and listing what they do. That process, what we would call, it's part of the development process, the VCAA notice, would sometimes take months. So we would send a veteran a letter, we would have to wait 30, 60, 90 days. We'd have to send the veteran another letter, wait another 30, 60, 90 days. And because of us being required by law to provide the veteran with these certain notices, it was prolonging these claims. We're required, the veterans would call in, understandably upset, understandably frustrated. Why are you asking me for this information? I sent it to you last month. Unfortunately, sir, we're required by law to ask you for that information again. And it was a bit of a convoluted process. So finally, somebody, somewhere, came up with the idea of, let's not just do this Fully Developed Claim Program where these claims are submitted in a nice little package, but at the same time, we're going to provide the veteran with their VCAA notification, their 5103 notification, up front. Here you go, Ms. Veteran. Here you go, Mr. Veteran. Thank you for filing your fully developed claim. Here are all of your notices that we're required by law to give you. So those are your two parts, the notice and then the actual application itself. As with every other form, I'm sure you all fill out, being either service officers or lawyers or just American citizens, you all know that the United States government likes their forms filled out in full. So, as with everything else, please make sure the form is filled out completely and submitted to, and this is new, the centralized mail facility. You still can submit applications and evidence and whatever else you want to submit to the VA. You still can send that to the regional office. However, the VA now has gone to centralized mail facilities. We have 2 in the nation: Illinois, Missouri, Kansas, and then 22 other states send all of their correspondence to Janesville, Wisconsin. They scan it in. Because we're paperless now, that's why we want everything to go to the scanning facility. Used to be it'd come into the regional office and be processed, and we had claims folders the size that we'd have to sort through, but now everything is paperless, and we have this new system, so we're requesting everybody send all of their information to these scanning facilities so it's scanned in. Here's that notice I was talking about, the 5103 notice, duty to assist, also called VCAA, Veterans Claims Assistance Act. When your veteran or claimant, depending on what is being filed, fills out that application for the fully developed claim, this will be attached to it. The legal jargon, no offense meant, it's just what it is, the legal jargon that we, the VA, are required to provide veterans and their advocates, this is a very basic description of what is on that form. So the 21526EZ that we were talking about with compensation is the service connection, active duty for training, inactive duty, so reserve and guard members, increased disability compensation if the veteran already has a service-connected disability and they are filing for an increase, the TDIU that Professor Drake mentioned, unemployability, temporary disability because the veteran was hospitalized and due to a service-connected disability, the 1151, which is what Professor Drake equated to a tort, kind of a malpractice claim against the VA Medical Center, the special monthly compensation for the aid and attendance. Somebody earlier, I think it was Dr. Oki, was speaking, one of her veterans said that he was receiving the highest amount of money you can unless you're in a vegetative state. That was referring to special monthly compensation. That's the amount we pay over and above 100% for aid and attendance or loss of a limb, various disabilities, adapted housing, special home adaptation, auto allowance, adaptive equipment, helpless child, seriously disabled child. This is a list of what can be filed on the 526EZ through the fully developed claim program. So if you have a veteran that is wanting to file one of the claims based on the malpractice against the VA Medical Center, the veteran says, I was at the VA Medical Center and my surgery went wrong and I would like to file one of these claims. Well, you need to look and see if it's possible that we can file this fully developed claim on this 526EZ. And the answer with that is yes. 3 claims that are excluded from the fully developed claim program. And I have to give you a kind of a disclaimer. I have no idea why. I don't, and I can't get anybody really to answer me. I think somebody in Washington, D.C. Made the decision they made, and so these 3 are not specifically covered by that fully developed claim notice. So that notice that we send with these forms does not include permanent and total status, which means, say, a veteran is 100%, but they have a future examination. That's not permanent and total. That's not included. Claims for hepatitis C infection and its residuals, for whatever reason, are not included. Claims for that higher level of SMC. Dr. Oki's veteran that said he was at the highest amount he was able to be paid without being in a vegetative state. Well, this higher level of SMC is that vegetative state, that R2. That's a totally different training class. The 527 EZ, so the fully developed claims for the income-based benefit Professor Drake mentioned, that's improved pension, special monthly pension, pension based on a helpless or seriously disabled child. This 527 is for the income-based benefit that she discussed. That is for veterans with wartime service. The 534 EZ for the survivor claims includes the accrued benefits, DIC, which is the service-connected cause of death, or under 1318, which is a different regulation, a different statute that covers the amount of time a veteran was at a total disability percentage. But again, that's a totally different training class, so sorry. Active duty for training, death pension. This is your survivors' claims, and that's what's on the 534 EZ. March 24th, 2015, the VA changed the way it accepts claims. We went to a standard form process. Most other federal agencies, you had to file a claim on a very specific form. The VA was not like that. The VA, prior to March 24th, 2015, the VA accepted claims on everything. You'll hear stories from regional offices about claims being submitted on paper towels, bar napkins, articles of clothing. VA would accept a claim on anything that veteran could write on and send it in. One or two, I know for a fact, one or two pairs of undergarments have been submitted with VA claims written on them. Yes. So VA, March 24th, 2015, said, we now have to submit these claims, accept these claims on a prescribed form, on a required form. So they created what is now called the intent to file process. That is the VA Form 210966. It's the bureaucracy of the federal government. We all love these forms. That protects an effective date. If, for instance, you have a veteran that you're working with, and you know that veteran wants to file a claim and is probably eligible for benefits, but you don't have everything together yet. You need a few months to gather all of your evidence. You need some time to get the information you need. You can submit this form that is an intent to file form. Hey, VA, we intend on submitting a fully developed claim or any type of claim, as long as it's on a prescribed form, within the next year. So the minute you're working with a veteran, if you think that veteran's going to want to file for something, have them submit an intent to file. That intent to file form replaces the informal or incomplete claims that veterans used to be able to submit on everything. So the bar napkin claims have been replaced by this official form. And as I said, the effective date is protected. And after March 24, 2015, no claims will be accepted unless on one of the official forms. Now, you don't have to submit the intent to file a claim. It's not required. You can submit a general application using just the regular 21-526 anytime you want. You can submit a 21-526 EZ for a fully developed claim whenever you want. You don't have to use the intent to file form. It's just a placeholder. It's a save the date card for when the VA eventually adjudicates that claim. Now you have 1 year from your intent to file to formalize that claim, or you'll lose your date. Unfortunately, sometimes we have to exclude claims from the FDC program, and that's okay. Really what it does is it puts the claims in the general population of adjudication. So right now, the worst that can happen if a claim is excluded from the FDC program is it slows it down some. And I say right now because up until August, there was a different program in place, and I'm going to go over that in just a second. So, for instance, some exclusions from the FDC program. The claimant indicated a desire not to have the claim processed in FDC. They checked the box that said, no, thank you. It's different, it gives you the list of where the different boxes are. The veteran had a separate claim pending. They filed a claim 6 months ago. They wrote in again and said, hey, I'd like to file a claim fully developed for this. Sorry, you already had a claim pending. There's an appeal pending at the time of receipt of the form. The claim requires a character of discharge determination. The claim requires any kind of development at all, except for federal records, VA treatment records, a VA examination. In that case, if it's something we have to go for ourselves, we will not exclude it from the fully developed claim program. If it's something that we have in our custody, we being the federal government, so that's VA records, Social Security records, we will not exclude a claim from FDC for federal treatment records or federal records. If the veteran fails to report for an exam, they'll be removed from the fully developed claim program. Professor Drake spoke about how important it is for your veterans to go to their exams. They have to go to their exams, especially if they're pursuing a fully developed claim. If we set up an exam, it's one of the main bits of evidence we need. If we receive additional evidence, if we receive a notice of disagreement, if we receive a supplemental claim, then we'll remove the veteran from the FDC program. And when I say veteran, I mean claimant as well, because I know that it's not always a veteran filing these claims. Sometimes it's a survivor. We will send a letter if the claim is excluded that says, you've been excluded from the fully developed claim program because of this, blank. Keep this in mind. I'm going to come back to this in a couple minutes because you all as advocates, I'm going to try and give you some insider information. It's not secret, but it's stuff I've learned through the years that will help you. So keep this in mind. This letter that we send to the veteran, notifying him or her why they were excluded, it's important because you want to pay attention to that later down the line. Despite the name, these claims should not be expected to be ready for a decision immediately. They are moving more quickly. They are moving faster, but they should not be expected to be immediately ready for a decision. Sometimes we have to do additional development. Sometimes we have to get that VA examination. A lot of times veterans submit it and in a month say, why haven't I received my decision yet? They do move faster. In some cases, very rarely, we will have to send a development letter to the veteran. If federal records aren't available, if the veteran identifies those federal records and we can't get our hands on them, special issue development, Agent Orange, asbestos, radiation, fire-related cases where we can't find the records because they were burned up at the fire at the wherever the fire was in St. Louis in the early 70s. We will request this information from the veteran, and if we receive it, we will not remove the veteran from the fully developed claim program. However, if he or she submits anything else, they're out. So if we write and say, your federal records are unavailable, please submit any service treatment records. If they send us service treatment records, they can stay in the program. If they submit service treatment records and private treatment records from Dr. Smith down the street, they'll be removed from the program. And they're notified of that when we request the information. This is a general paragraph that we send when we're unable to obtain federal records. This is all required by our regulations. Our regulations tell us what we have to do. Oh, this is part of where we talked about everything being wrapped into a nice, tight little bow. This is part of that. In this program, if the veteran has seen a non-VA doctor, a private doctor, and wants us to have those records, that has to be submitted from the beginning. So the private records from Dr. Smith, the private records from Dr. Jones, that has to be submitted at the very beginning. Because if the veteran submits the fully developed claim, and then later on decides that he or she wants us to have these records from Dr. Smith or Dr. Jones and sends them to us, we will remove them from the program. This is a good place where your intent to file comes into play. If you've submitted your intent to file form, you have a year to obtain all of these records from Dr. Smith and Dr. Jones, put it together, and then give it to us. The 2140-142 that it discusses is the authorization that a veteran gives us in order to go obtain these records. This will immediately kick a veteran out of the fully developed claim program. Why? Because they're supposed to be submitting that stuff to us when they submit that claim. As I said earlier, if the veteran identifies federal records, we'll develop for them. However, if the veteran has federal records in their custody, we need those. It's much easier for that veteran to just say, here are my Social Security records, you can have them. This is why they're important. Here are my copies of my service treatment records. That's very helpful. But it will not remove the veteran from a program. Okay, do you remember earlier when I said that right now, the only negative to come from being removed from the FDC program is that it slows the claim down? Right now was the operative word there. Because for 2 years, from August 2013 through August 2015, veterans who submitted a fully developed claim for original compensation, so the very first claim this veteran has ever submitted to the VA, for those 2 years, if we received that claim, it was fully developed, it was the very first one they ever submitted, everything was fine, they remained in the FDC program, we granted a benefit, we were able to pay them 1 year prior to the date they actually received we actually received the claim. It was an incentive, essentially. I don't know if that was the official term from Washington, D.C., but I would say it was an incentive. VA wanted to boost these fully developed claims, and VA wanted these FDC claims to take hold. So VA said, okay, if you've never filed a claim before, and you file a fully developed claim for compensation, it stays fully developed through the entire process. We grant you benefits. We're going to reward you by paying you 1 year prior to when you actually submitted that claim. So for those 2 years, that's when it was important whether or not a claim was removed from fully developed claim status. Because it's possible that that veteran was losing that 1 year of retroactive entitlement under Public Law 112-154. That gives you the general legal information, 1 year retroactive effective dates, awards, original claims. So if you're advocating for a veteran and you are looking at a recent decision, you definitely want to look at, when we're talking about Public Law 112-154, you definitely want to look at, was this an original claim? Meaning, is this the very first claim this veteran ever submitted? If the answer is yes, you want to look and see if it was a fully developed claim, an FDC. If the answer to that is yes, you want to look to see if it was filed between these two dates, August 2013 and August 2015. Because if it was that as well, there's a good chance that veteran should have received a 1 year retroactive effective date prior to the date that claim was received. So, the other note that I made when I said we're going to come back to this later, it's important to pay attention to that letter where the VA notified the veteran why he or she was removed from the FDC program. This is why. Because for those 2 years, if VA erroneously removed someone from the FDC program, there's a possibility that we were also removing them from entitlement to that 1 year retroactive date. So watch out for if you have a letter that says you were removed from the fully developed claim program, watch out for the reasons why, particularly if it was an original claim filed within these dates. For instance, combat veteran. It's all over the DD 214. Very first claim ever filed, original claim, fully developed, received in January of 2014. we ended up granting PTSD. Technically, under the law, we should have granted 1 year prior to the day we received the claim. Somehow, the VSR missed that this was a combat veteran. Somehow, the VSR didn't really see it and removed that veteran from the fully developed claim program. Well, because the veteran, the reason they gave for removing the veteran from the fully developed claim program in that case is because the veteran didn't submit evidence of his stressor for PTSD. Well, this is a combat veteran. We know his stressor. The combat is documented all over the DD 214. We don't need the separate statement in that case telling us that. So I pulled it and was looking at it for quality, and I kicked it back to both the VSR and the Raider for training purposes and said, this veteran never should have been excluded from this program. This veteran should have remained in FDC because it was original and because it was received within those 2 years. We owe that veteran a year at 100% disability. So it was a $28,000 mistake. And unfortunately, it happens. It's human error. And that's why those little tentacles I mentioned earlier of our veterans advocates and you all being out there and helping our veterans and knowing some of these little nuances or knowing who to ask about these little nuances, that's why it's important. So when you're looking at these claims and reviewing stuff, just pay attention to why they're removed from FDC. These last two bullets here, because we changed everything around on March 24th, 2015, prior to March 24th, 2015, we had to wait until the formal claim the FDC had been formalized. So prior to March 24th, 2015, it was 1 year prior that we could pay to the date of the formal fully developed claim, not the informal, not the intent to file, none of that. After March 24th, so from March 24th, 2015 through August 5th, 2015, we could possibly pay an effective date up to 1 year prior to the receipt of the intent to file. So there's just some little nuances with that FDC in this Public Law 112-154. Compensation, I'm going to run through these last couple quickly because I think I have about 5 more minutes. The claim has to be for compensation, formal and original, as I said. It has to be fully developed, meaning filed on the correct form between August 6, 2013 and August 5th, 2015. This just talks about the evaluation. The evidence has to support the evaluation. So for instance, in the PTSD case I just discussed, we had VA Medical Center evidence showing that veteran should have been paid at the 100%. If the VA medical evidence would have shown for that 1 year retroactive that he should have been 30, then we would have paid at 30. And then, so it's based on the evidence that we see that 1 year retroactive period. This is, sorry about the question mark, that's a lie. We'll answer some questions later. That's all I have on FDC. I know it was a lot. Sorry, I see heads bobbing around, and I feel like I'm turned into a talking head. Is this where the Irish drinking songs come in? You want me to bust 1 or 2 out? So that's the fully developed claim. Do you want me to stop there, or do you want me to run through this real quick? Are you sure? Okay, I'll go through this real quickly. That's the fully developed claim program that Professor Drake wanted me to discuss. She had also talked about just bringing up some general VA knowledge. What would I want to tell a group of veterans advocates? Some miscellaneous appeals information. I know that they said I was a decision review officer. That is what I do. I was a decision review officer doing quality control in the regional office, and now I'm a decision review officer doing appeals work. I had done appeals work in Chicago as well. So I kind of see it from both sides. And before that had been working for DAV and a general advocate for veterans. So I know we're going into the appeal, and I don't know where Amy Odom went, but I was hoping she would hear this part. I know we're getting ready to discuss the appeal process a little bit. And one thing I wanted to bring up is a fact of law, a fact of the statute. Oh, there she is. And you could correct me if I'm wrong or just throw something at me if you want. is a fact in the statute that a lot of time is overlooked, that a lot of advocates and veterans and service officers and powers of attorney overlook. And that is the option to file for reconsideration or file new and material evidence. When a veteran is provided a rating decision, giving them a decision on their claim, or a claimant is provided with a decision, they have 1 year to either appeal or submit additional evidence that will allow us to reconsider that prior decision as if it was never made. A lot of people don't do that. A lot of times they automatically appeal. I object. I file a notice of disagreement. I want to go the appeal process, and that's absolutely fine. That it's there, that's what it's for. But the reconsideration method usually goes much more quickly. Here are our regs. 3.400, 38 CFR 3.400, new material evidence, as if the former decision had not been rendered, as I said a second ago. 3.156B, if you submit new and material evidence within the appeal period, you're not filing an appeal, you're submitting new and material evidence. It will be considered as if the claim was pending at the beginning of the appeal period. This is, you all can read this on your own, I'm gonna talk about it. Pending claim, finally adjudicated claim. Basically, one of the things I see most, especially in working appeals, is where there's a piece of evidence out there in space that I needed to grant that benefit, and I never received it. I made the decision, I was unable to grant the claim. 6 months later, the veteran appeals and says, I object, I want to go through the appeals process. Oh, by the way, here's this piece of evidence that you needed to grant that claim. If that veteran would have just submitted that evidence and asked for a reconsideration or asked for us to take another look at it based on new and material evidence, we could do that immediately, grant the benefit and move on. But because that veteran submitted that evidence and said, I want to appeal, they've immediately, at the very least, prolonged their wait a year, because that's how long it's taking us to get to notices of disagreement in our office. So my tip here, my trick, and look at the regs and look at everything, and if you have any questions for me, please ask. But what I'm doing is encouraging you not to not file appeals. File all the appeals you want. We'll handle them eventually. But if you have that piece of evidence, if you have that copy of a service treatment record showing boots on the ground in Vietnam, if you've got that golden ticket that's going to allow us to grant a benefit, instead of submitting that in connection with appeal, submit it within a year of when that decision was made, so during the appeal period, but submit it as a reconsideration request. I'm requesting you reconsider the previous decision. Submit it as new and material evidence. Because not only is that a faster process than going through the appeals process, it will also it will also allow us to give the effective date as if that prior decision had never been made. Think continuous prosecution. So arthritis claim 2010, arthritis denied 2011, within a year, additional evidence is received allowing us to grant that arthritis, that's an arrow up there. Because it was submitted within that year, where's the pointer? Is this gonna work? Yay. Because it was submitted within a year of this denial, it's as if this denial never happened, and we're allowed to go all the way back to when that claim was filed. Yes, ma'am.
I do have something to say.
Uh-huh.
You want me to wait?
No, go ahead.
Okay. This I would never do. And the
Okay.
reason why is that if you submit that evidence on the very last day, you run the risk of A, it's just being completely ignored or treated as a new claim, and then you have to go through the appellate process to get the correct effective date. Or what if it's not actually new and material? And you thought it was, but it turns out that according to the adjudicator, there's something that is cumulative of something that was already in the record. If you submit that on that last day and never file an
It depends. I don't disagree with you. And like I said, if you have something that is going to overturn this denial definitively, like evidence of Vietnam service, and you're adjudicating a claim for Agent Orange exposure, you do have to be very confident in this evidence that you're submitting. She's absolutely right. To address the issue of when it's submitted, technically, as long as it's within that year, we're allowed to go all the way back, as if this never happened. Now, is there sometimes human error involved? Yes. Do sometimes rating specialists miss that? Yes. But you work through the process, not necessarily appeal it, but you work through the process and say, hey, I really should have had an earlier effective date for that. You say that a clear and unmistakable error was made. That's a part of you don't have to go through the appeal process to do that. You have requests that they take another look at it. So while we may, on the regional office level, we may differ a little bit than what is happening up at the court level. Like Amy may have a different take on things. At the regional office level, I do see this a lot. And submitting this additional evidence a lot of times will allow us to overturn this, and you've knocked off an entire appeal period. So we may have a little bit of a different take on it.
Well, I would do this, but I would modify this to say if you have the new evidence, submit it early.
Yeah.
And if you don't get a decision on that new evidence by the expiration of the year after the rating decision, to file your notice of disagreement to ensure that you're preserving your client's rights. Because especially attorneys are held to a pretty high standard. So doing this on the very last day and not being fully aware of what's in the claims file, which can happen a lot for attorneys, runs the risk of malpractice even if you haven't preserved your client's rights to appeal. So that's why I agree with what you're saying. In fact, Gerard was my case. I argued that at the federal circuit. So I'm a strong believer in 3.156B. But I think that waiting to the last minute like that is super risky. You should do it earlier in that year if you're going to do it.
This is for examples only. Sorry? Huh? Yeah, this is just an example, and it was kind of to get people thinking in the training that I had given earlier on it. And she's right. If you have it, do it earlier, but you do have that 1 year period after that denial in which to do it. So thank you, though, for the feedback. Absolutely. All right, we're going to move ahead one more. Some other miscellaneous things. The St. Louis Regional Office. Our BVA hearings wait times are years. And that's just the nature of the beast, unfortunately. Hopefully BVA will start to process these through a little bit quicker. But for right now, our wait time for BVA hearings are tremendous. And I bring that up because a lot of times when we go to these Board of Veterans Appeals hearings and see them, a lot of times everything that's happening in the hearing, everything the veteran wants to present could have been submitted in a written statement. Everybody is entitled to, they want their day in court, they want their hearing, and they show up, and a lot of times it's me sitting if it's a DRO hearing. But the BVA hearings are the ones that are taking a little bit longer. So if your veteran or claimant wants a BVA hearing, it's there. Have them do it. But if it's something that can be submitted in a statement, make sure they're aware that they may be able to knock a few years off their pending appeals by submitting a statement instead of waiting for the hearing. I'm not discouraging people from asking for hearings. I'm not discouraging people from requesting them. I'm simply saying that there's a possibility of knocking a few years off your pending appeal if you can get the veteran to submit a statement or type something up and let us know. We already talked about the incorrect exclusions from the FTC. And then the Waters v. Shinseki, I would, as advocates, if I were you, watch out for VA not requesting examinations based on the veteran not providing evidence of a link. Pay attention to that. At the regional office level, we were essentially told that if the veteran writes in and files a claim and does not indicate some sort of link, it's within our legal authority because of this Waters v. Shinseki to not obtain an examination. The pendulum has swung. We used to be swinging to the left where we would get an examination or a medical opinion asking for the nexus on everything. It's swung the opposite direction now with this Waters case, where we're not asking for very many nexus opinions at all. And it's based on this case. It doesn't fly at BVA, it doesn't fly at the court, but at the regional office level it does. So watch out when you're advocating for these veterans. Why did we not obtain a medical nexus opinion when really we probably should have? And a lot of times you'll see it's this Waters case. So that's all I have. I'm sorry I went a little bit over. I was afraid I was going to do that.
That's okay. So let's take a break. There's cupcakes and cookies and drinks and we got some more news. You gotta listen to basically 5 times before this. So give yourself.
I was a group, I was really hoping they would break my door.
Oh, hello.
That works. Good afternoon, everybody. Been a super conference, symposium so far. I am now going to teach you everything you need to know about the VA process in 20 minutes. There will not be a test. Very quickly, let us strive, the words of Lincoln. And just to let you know, this group down here in this picture, that's John Wilkes Booth and two of the conspirators. But we'll roll along. We'll skip the history real quickly. The VA and one from another has been around. This is my favorite number. In 1890, 34% of the federal budget went to veterans. In 2013, it'd be over $1 trillion. I'm still waiting in Washington. And it grew, and it grew, and it grew. But there was little substantive change. And I'm going to come back to that because that sort of outlines, it's a little busy, and it sort of outlines the whole thing. First of all, you start out at the regional office. That's been covered pretty well the last few minutes. And if you're not happy with that decision from the regional office, you've got 1 year to file the notice of disagreement. 1 year. If you don't get it in a year, then you get to do other litigation that we shouldn't have to do. Form, statement of the case. That's what the VA prepares in response. You do the NOD, they come back with the SOC, and then you make your decision. Every once in a while, somebody says, well, let's go back with another NOD, and then you get a SSOC, which is the supplemental statement of the case. That's really probably one step too far, unless you found some new evidence. Okay, you may request a decision review officer hearing during this time. We just had a question about that. Do your homework, check around, see what's coming out of that office. We've seen some good results, and we've seen some, I'll say, non-results, because you're really no worse off than you were if they deny it. And you may submit any evidence. We just had a discussion about that. So anyway, you get the notice of disagreement, you get your statement of the case back, and you are basically done at the regional office. Okay. You're really done, and what do you do? Where do you go next? You go to the Board of Veterans Appeals. That's a group of happy or not so happy people in Washington, D.C. They call it a board because they have a lot of people. They do not sit as a group. Each is considered a judge, although I will add that they are not administrative law judges. They are VA employees with a great deal of experience. 60 days after the statement of the case. That's one of the shorter time frames that is involved there. You get the Form 9 in. The Form 9 will go back to the regional office so that they can prep the case to go up to the Board of Veterans Appeals. You will elect whether or not to have a hearing before the BVA, and I think that was just pretty well covered about what to do or not to do. The thing is, you will have a lot of people, this is an anecdote, we'll try to make them short and sweet. You will have veterans who will who say, I have to tell them myself, I want to bring them my story. And usually what happens is they try to snatch defeat from the jaws of victory. Well, you've already lost because that's where you're going, but You may have been able to develop a good case by then. I got to tell my story, and disaster sometimes arises. You can submit additional evidence. That's a reason to go forward with it. I have heard in the last few months several stories where certain people were telling veterans, you don't appeal, you just file a new claim. No. Keep the appeal process. There will be exceptions. There's always exceptions. But you need to just keep on moving on up. The Veterans Judicial Review Act changed the whole landscape. It brought lawyers into it. It created the U.S. Court of Appeals, well, it's now the U.S. Court of Appeals for Veterans Claims. All courts, there's a rule, unwritten, that all courts have to change their names within 10 years after being created. It gave the VA cabinet status, and the Veterans Administration, which I grew up with, became the Department of Veterans Affairs. There's our neat CAVC intro slide. If the appellant is not satisfied with the board's decision, he or she has the following options. He can file a motion for reconsideration. Take a note. If you have a slide out there or anything with this on it, draw a line through it. This is not the reconsideration at the regional office. This is a reconsideration of the board's decision. If you do that, you have a 99.2% possibility of being turned down. It is a waste of time. I've been doing this 15 years. I have seen twice where the board said, okay, we'll listen to it again. And that's not granting. That's just saying we will listen to it again. We'll take another look at it. That's not granting. File a motion to vacate. That just creates confusion. A motion based for revision on clear and unmistakable error. If you get into this a little deeper, CUE is a very high standard, and I haven't seen any of these in a long time. Or you can file your appeal to the U.S. Court of Appeals for Veterans Claims. Notice of appeal. This is one of the great sources of job security for attorneys when the folks file it a little bit late. I am very proud that my organization filed a case called Henderson. It went to the Supreme Court. I don't have time, or probably the intellect, to get into why it went that way. But equitable tolling, which had been taken from the process by the Veterans Court, was reinstated by the Big Nine there on Capitol Hill, and 8-0. One person, I forget who, did not vote for whatever reason. So if you have a vet that comes in and says, I was late, make further inquiry. Was he in the hospital? Was there a bad mailing address? We just placed a case. We're going to go back. The vet was 80-something years old. He was in poor health. The court said, no, we're going to turn it off because he didn't submit any proof that he was ill. The man is 85 years old. Anyway, we're going to go to the mats on that one. Necessary form to get back to your normal process. The notice of appeal is Form 1. The $50 filing fee or a declaration of financial hardship is Form 4. You don't need to pay the $50. The court, as far as I know, in the 20 years the court has, tell them it's hardship. I say this for two reasons. First of all, for most of our clients, $50 is a hardship. It is money that they work hard for, hard to come by. And secondly, I frankly don't believe that any veteran should have to pay $50 for the court to hear his thing. That's my policy. It is not attributable to anybody else that I know of, but blame me. I understand 23 years, 24 years the court's been in existence. They declined, they turned down once, and they figured that maybe a retired brigadier general really should pay his $50. Notice the docketing, the court kicks it out. It assigns the case number, the docket number. Note the docket number is different from the VA claims number, and provides instructions for both parties and sets out docketing deadlines. One of these things, And hold your breath, everybody. It says within 30 days, the VA must provide a copy of the BVA decision on appeal. With almost without fail, the board decision is posted in 3 working days. If they could apply this to everything else, we'd all be out playing golf with Angela. That's not fair, but anyway. Okay. The record before the agency, this is kind of new with the revision of a few years ago. What happens is the RBA, the record before the agency, is materials in the claims file on the date the board issued the decision. It's other material from the record that was before the secretary of the board, and it can list any record matter that cannot be duplicated. So if the guy has a 2.5-ton military truck he wants to include in record, you take a picture and you note that it's there. I don't think I've ever seen that used. There's 2 parts to that. The first part is we're in that transition stage now between sending a disk, and that's what my folks use, and the other part of it is sending the hard copy. Technically, and I think it actually works, the vet may ask for the hard copy, and usually they're getting it, and if not, they complain to somebody and it all gets worked out. The other thing is some of the folks that work with us, all great Americans and great lawyers, do not believe in going over the RBA with their client. I'm one that thinks you should. I'll give a quick example. Let's pretend I had a hearing claim, and once upon a time I was up in Philadelphia as a military judge. I had an earache. I went in, they gave me one of those cotton wicks for all you old folks who used to get swimmer's ear. They wrap it around and you scream. As far as I know, that documentation never ever went anywhere and was probably burned down with the Philadelphia Medical Center once upon a time. So, no one would know. If I'm not asked about that, there's no record of it. Nobody knows about it. Nobody can ask for it. So, my suggestion, sit down with your client, go over the RBA and see what's out there. You may learn about other claims going through that. Okay. The appellant may file a motion to dispute within 14 days plus filing 5 mailing days. I'm not going to spend much time here because if there is a dispute, then the central legal staff gets into it and they try to sort it out before it goes to the court. The appellant's brief. If both parties agree on the content, the clerk will issue a notice instructing the appellant to file a brief within 60 days. Pretty simple. The informal brief. Now, the pro bono program has started a process where we assist veterans whose case we cannot take. We look at it, we screen it, we review it. We'll talk to each other if it's a denial. But we believe that the vet should get, or the widow or family member should get the day in court. And we provide a very broad, very general advice on how to fill out the form. We provide a lot of insight about what the words mean. We start out with things, do not start your informal appeal with an F-bomb to the chief judge, which actually came through our office once. We got that out of there. But it's a service, and we move very carefully with it. But again, if you've got a veteran at this stage, you're writing a brief with all that entails. And make sure your margins and your font are correct. Secretary's brief, they get 60 days to come back at you. The reply brief is optional. I think it's 14 days? 15 days? Yeah, like this, come back kind of quick. And it's a May, you don't have to do that. This creates the record of proceedings, which is a collection of materials required to decide the appeal. Basically, one of the reasons that you should include page cites in your brief is that documents will be brought into the record of proceedings. The secretary must file and serve the ROP within 14 days of the reply brief, so it gets a little busy. And the appellant may file a motion to dispute the ROP if pertinent documents are missing. Let me just say that as with this copying of records to put them on the disk, we see from time to time, and I know you guys do too at NVLSP, things go missing. It's not a question of anybody's trying to hide anything. It's just when your job is to sit there and copy 14,000 pages one at a time to put them on the disk, things happen. So you need another review, perhaps with your client, to make sure that everything that was in the RBA that you want in the ROP is there, because this is what the court uses. The judge's decision, most cases are one judge. I think 80% is the last number, maybe a little higher. Some cases may be decided by a panel of 3, and that usually is preceded by an oral argument, although they have one process that drives me nuts. They grant the motion to hear a panel decision, and then they write, okay, we've granted panel decision, and the panel's looked at it, and you know what, the one judge got it right, so affirmed. I guess what that means is 3 judges have now looked at your case, one of who looked at it before, and you reached the same result. Possible decisions. As Angela said, it's a brave new world, the magical mystery tour of the veterans law process. And this is where it really gets a little different. Actually, it gets a lot different. They will affirm, they may affirm the board decision, which is basically saying the board got it right. And then you say some other issues to think about. Remand. This is the thing, that you don't get a final decision from the Veterans Court. A remand sends it back. They'll vacate and remand, and they go back, and it goes back to the case management center at the board, and they play with it there. If there is an examination required, then it goes, it will probably go back to the regional office. But there are no final decisions. We call it the hamster wheel. But a remand is a victory. You've kept the ball in the air. It goes back. They will do it again. Hopefully your client will prevail. And if that does, then the client gets a check. And he's happy, we're happy. And it's one off somebody's desk somewhere. A reversal that's an outright win. I think in 20 years I've seen about 3 reversals. My personal favorite was the chief judge wrote the opinion. He said, "You're trying to tell me that you're not going to pay this widow the benefits because there is no proof that her husband is a veteran." And yet, in the same record, and this was the judge's tone actually, you're telling me that the veteran, or that the widow's husband, is buried in a national veterans cemetery. And Ken Kramer is a true gentleman, but I think in his heart of hearts he would have liked to have said, "What the hell are you doing?" So anyway, widow got her benefits. That's about the only reversal I remember. And it's a rare thing. I probably should have framed that case. Vacate, they throw it out. If no jurisdiction, they'll dismiss it. What happens on those sometimes is an appeal will go up, and it'll get there, and you'll find out that the cases that it occurred outside of the VA's range of jurisdiction. It's just, we're done with it. We have no authority to make a decision on this case. Sometimes they actually get up there where there is no board decision. Those don't go through us because we would not pursue that. But anyway, big thing, affirm is a win for the VA, a remand is a win for the veteran, although the game continues. Appellant may file a motion for reconsideration of the decision within 21 days. You have to lay out the basis for your request, which is hard if you're pro se. The lawyers can do some good things. We've picked up, Henderson was actually a reconsideration case, the case that went to the Supreme Court with equitable tolling. We were looking at it, thought it was horribly unfair, and did a reconsideration. And about 2 years later, Supreme Court came down on our side. Judgment is entered after 21 days after the decision, unless the reconsideration is filed. And now, what are your options? There's also a mandate, which will pop up here in a second. You can take it, our next appellate level is the Court of Appeals for the Federal Circuit. You have to file that within 60 days of judgment. We sit down, we have some nice help. The Bar Association of the Fed Circuit will look at cases for us. They will look at cases for anybody if there's some merit to it. Sometimes it just sort of, if the veteran wants to go up on his own, that happens. And again, we provide some slight guidance. And then, of course, the appeal to the Federal Circuit, of the Federal Circuit decision, we will run that up to the Supreme Court. I don't say run it up. We have a case called Scott. A lady named Jennifer Naw works for Baker Botts, has had the case, and she believes that it merits the Baker Botts Supreme Court practice section agrees with her, and we're scrambling around looking for people to file amicus with us. The issue, very simply, is the vet was in jail, was incarcerated. The VA wanted to give him an examination. He said, I may get out. I get out in March of 2014. They scheduled their appointment for March of 2013. So he didn't show up. And as the appeal went back and forth, he continued it on the substance, but he also continued it on at the Veterans Court, continued it on the fact he'd been denied an examination. And the Veterans Court said, well, too bad, so sad. We don't do piecemeal litigation, and you haven't exhausted your remedies. And we're not going to litigate it. So Ms. Null and the folks at Baker Botts and some other folks around the area of practice don't particularly agree with that. So they went to the Fed Circuit. Fed Circuit agreed with the Veterans Court, and we'll see where it all ends up. But it's Scott versus McDonald. Remain open through the appeals process, and once the Fed Circuit and the Supremes reach their decision, mandates 60 days after judgment. That just means it's over and done with. And this brings us to the Equal Access to Justice Act. It's a separate pot of money. Some people like it, some people don't. But there is 30 days after the mandate, and this is what you have to tell your client if you are going to file for age of fees. It's a different pot of money. It does not affect one dime of any award you get from the VA. I think I'd been working there about 3 days, and I got a call. This is a long time ago, of course. And I got a call from some guy who says, I don't want my lawyer to get any money from my award. And I didn't have a clue what EJA meant at the time. Been there 72 hours. So I learned, and we went from there. But it is what it is. How much time do I have, if any? 5 minutes? Let me start over again. Let me offer a couple of practice thoughts. First of all, a professor named Mike Allen wrote an article. Didn't get much circulation. I don't think he published it, but it's very cool, and it's I think a nice guideline for when you start representing these people. It's called it's 3 C's: competency, consultation, and I knew I would do this. What's the third one?
Communication.
What? Communication, yes. Thank you. Very good. Competency, you're probably a pretty good lawyer at what you do every day. But you're going to have to work a little bit to be a competent veterans law person. And we've got people to help you. If you take a case through us, we assign mentors like Amy and other folks at NVLSP and some other very professional people to help you achieve the competency that your client requires. Consultation. A lot of your questions will be things that don't require work, they require an explanation. Tell them what this means, what that means, what could or could not happen. You will make for a happy client. And finally, communication. You're going to have to listen. Listening is a skill that we don't talk about very much, and I will be honest with you. I have, on occasion, set the phone down on the thing and done something else and let my client rant. That's okay. I've been listening, and at the end of it, he or she will use, "I'm sorry, I didn't mean to get upset." And I said, "That's okay, that's fine." Every once in a while, something will come out of that conversation. But it's not a freebie. You don't get to just say, "Oh, well, I'll talk to this guy or gal once every 30 days. And part of that, too, is you have in this practice, you have long periods of time where nothing happens. Despite the best efforts of the VA, nothing happens. And if once every 30 days you call up the Widow Jones and say, "Widow Jones, just checking in, nothing's happened, how are the green beans coming up in the garden?" Well, the Widow Jones will be happy, and I won't get, you won't be getting snarky phone calls a couple of weeks later, that sort of thing. And finally, compassion. After this morning, I don't have to tell anybody in this room about compassion. You wouldn't be doing here if you didn't have compassion for the men and women who've served our country. I have had a marvelous month. I have shaken the hand of heroes several times this month. Tom Brokaw, when I was down at a clinic in Montgomery, Alabama. Tammy Duckworth, member of the House who lost her legs in combat. And Alex and Sean. That's 4 aces for me. I don't know what else to tell you except one last thing. Yesterday was, do we have any Marines? Former Marines? Where? Happy birthday and Semper Fi. Marine Corps birthday yesterday, 240. Give them a hand. On that note, one other note here that was scheduled in the margin. Education. Mike didn't touch on that. I will. Educate your raters. If you've got a guy and you can add about his ship. We were just talking about the ship going aground, firing, backing out. Educate that rater about the going ashore at Da Nang, what it was like in Kandahar. You can put articles in. And I like buddy letters too. Sometimes they're good things or not. But educate that rater. I will tell you one story, then I will really promise to sit down and shut up. Out of Chicago, and I love, the folks in Chicago do a great job. We very rarely see Chicago cases. They were in a training session, and the supervisor walks by and he stops, he looks and says, "Why'd you deny that claim?" And the young person looks up and says, Well, I never heard of a place called Owajima, so this can't possibly be true. IWOJIMA. The supervisor said, "Approve the claim and then come talk." Because history is a part of this. It gets overlooked sometimes. I mean, I've seen a case where a cook had a claim for being in combat. And they said, well, you're a cook, how could you be in combat? Because they were stationed at an Air Force base that got mortared 75 times during the course of the war, including 24 while this guy was here. If somebody had told that raider up front, included the Google article, we were talking last night, Google, use it. Make sure your raider knows it, and I love fully developed claims. Win the thing in the first inning, don't go to the ninth. So, thank you very much. God bless, and we'll see you later.
Thanks, Dave. So we began with Amy Odom and we end with Amy Odom, who most recently has edited the 2015 version of our Bible. So her name's on there. It's your first baby. And then hopefully we'll have time for a few questions after.
Okay, so can I just click out of this? All right, well, in the meantime, I want to make a correction and a clarification. Those of you who were following along with my TBI talk this morning, I was talking about the special ancillary benefits, including special monthly compensation. And I was talking about the special one for TBI, and I said this is R2, and that was totally incorrect. It was not R2, it's called T, SMCT. I don't know if you care, but I wanted to put it on the record that I am correcting myself. And then I want to clarify too. Amelia's discussion of the new material evidence within the year is absolutely correct. It's the right, it's a good method of getting that earlier effective date. I was just disagreeing with the timeline that was presented as an example and making clear that doing it on the last day is really risky. Okay, so that said, let's move on. And we're using NVLSP slides today, I have to do a quick plug for them, for us. If you are interested in getting into this area of law and you want a little support, if you go to our website, nvlsp.org, we have available for purchase the Veterans Benefits Manual, which is really quite an excellent publication. And we also have, we do webinars every month on special topics for lawyers, and then there's like a video and all sorts of other stuff. So even just poking around there, you might find something that'll be helpful to you. All right, let's get to business. So I'm going to talk about common errors that we see in VA decisions that don't come from Amelia.
Right.
And I'm going to talk about errors that you can find really at both the agency level, so when you come into a case and you're filing a notice of disagreement and starting the administrative appellate process, and also errors that you can only, pursue at the court level, because they're errors that only the board can make. So the first major thing is, Amelia kind of talked about the duty to assist. And what that is in 2001, Congress passed the Veterans Claims Assistance Act, which codified a duty that had existed prior to 2001, but really strengthened this duty on the part of the VA to assist a veteran or a claimant in substantiating the claim. They have to make reasonable efforts to help the veteran obtain evidence, which might be VA treatment records, service medical records, unit histories to prove that a combat stressor occurred, and in some cases, a medical opinion. And the only way they can get out of this duty is if there's no reasonable possibility that assistance would prove the claim. So think about how high of a bar that is. That's pretty high, right? No reasonable possibility. So these are the kind of things that we just talked about. They have to get records. Of course, you can't expect the VA to just kind of sit around thinking of every single possible record that could possibly help this veteran and then to go out and get them. There is a duty on the veteran to notify the VA of the existence of records that he or she wants the VA to associate with the claim. So that would be your job as an advocate, right? So you're going through the claims file, You know the veteran was treated in 1980 for back problems, but there are no records in it. But the veteran keeps saying, I was treated in 1980. You want to talk to that veteran, find out if he remembers even who the doctor was, where the doctor was, see if you can get those records. Or ask the VA to get them. And then if VA is unable to do so, they have to notify you and let you know what other information you can obtain. The duty to get federal agency records is higher than the duty to get private records. So I just actually had a big case at the Court of Appeals for Veterans Claims where we were arguing that the VA was, okay, long story short. So the VA has a rule in their adjudication procedures manual that says that in order for them to assist a veteran in obtaining military records to help prove a non-combat incident, the veteran has to narrow the window during which that incident occurred to 60 days. How many here can remember something that happened in college within 60 days? No, right? I mean, that's impossible. Now, imagine somebody who served in the Vietnam era. My client in this case was in Thailand in the Vietnam era and witnessed a person being crushed between two trucks because he was in a construction unit. So we took that to court and argued, well, they denied it because he didn't narrow the window to 60 days, and therefore they wouldn't get the records to prove that this thing actually happened. So we appealed to court and argued that that's a violation of the duty to assist, because the statute says you have to make reasonable efforts, and when you're talking about federal agency records, you can only get out of it if it would be futile to request those records, or if the records don't exist, and to require somebody to narrow it to 60 days is a violation of the statute, and the court agreed with us. So that kind of gives you an idea of how high this burden is. So the types of records that you usually need to have in order to prove a compensation claim include service medical records and other records related to service. That doesn't mean in every single case you need to have the service personnel records, but you probably do in a mental health disability claim if you're claiming that the disability began in service, or that it's related to a personal assault that occurred in service. Records of relevant medical treatment at VA facilities, usually your client is going to get treatment from the VA, and so you'll want to get those records, and they kind of automatically are associated with the claims file. And then any other relevant records that the claimant identifies. Remember, claimant still has a duty to identify them and authorize the VA to obtain them. There's all sorts of, Privacy Act and HIPAA considerations that go into the VA getting records. So the veteran has to file or has to sign an authorization, which VA will provide the form to the client. Okay, so exams. So this is what Amelia was talking about when she said sometimes they probably should get the exam and they don't, and they rely on this case called Waters. There's actually, just like there's elements to the claim, there's elements to when the VA's duty to obtain a medical examination and opinion is triggered. And that's found in the statute in a case called McLennan versus Nicholson. It's required if there's a medical diagnosis of a current disability or lay evidence of recurrent or persistent symptoms. So you don't necessarily have to have a diagnosis. If the veteran says, I have knee problems, that would be enough to satisfy this first element of this duty to assist obligation. And then there has to be, I really think about this in 4 parts, so I'm gonna tell you the 4 parts. The first is the current disability. The second is an in-service incident. So let's go back to the knee example. If the service medical records document that the veteran sought treatment for a knee problem, excellent, you're golden, you've got it. But sometimes veterans don't seek treatment in service. Sometimes they just tough it out. In that case, for purposes of this, of getting an exam, the veteran statements explaining having symptoms in service of knee problems will be sufficient. Even better if that veteran can contact buddies who served with him or her who will corroborate that they had personal knowledge of the veteran complaining of those symptoms. That's enough to prove an in-service incident. And then there has to be some indication, and that's an actual word from the statute, an indication in the record that the current disability or symptoms may be associated with service, which is a super low bar, right? We're talking about indications and that it may be, not that it is, not that it's at least as likely as not that it is, that it may be, because we're not talking about service connection right now. We're not talking about awarding benefits. We're talking about just the VA going out to help that veteran get the evidence to substantiate the claim, so the bar is even lower. And this can be lay evidence of continuity of symptomatology, so the veteran with the knee says, not only did I have knee problems in service, but they've continued since service to this day. That's enough, as long as it's credible, which means that, you know, you don't go through the treatment records and find that every time this guy seeks treatment, he denies any knee problems, right? An article that you print off the internet that says that knee problems can be associated with, you know, boot camp or marching with heavy packs. That would be enough to make an indication that it may be related. And then, of course, there has to be insufficient medical evidence for the VA to make a decision, which means there's not a medical opinion. And in most cases, there won't be, right? Because I kind of talked about this in TBI, when we were talking about TBI. It's really hard for a veteran to go out and get a private medical opinion. A lot of times, VHA doctors don't want to get involved. We do have the DBQs, but the DBQs really deal with like ratings, like what are the symptoms, what's the range of motion, that kind of thing. It's rare that I see a VHA doctor actually writing a text opinion that says, you know, the current knee problems are related to service and this is why.
We've asked them to mark in the mark spots.
Yeah. Yeah, but sometimes they won't do it because they don't. I've had them tell my clients that it's a conflict of interest, which is bizarre. I don't know whoever told them that. And a lot of people, you know, veterans are just like you and me. A lot of people don't have thousands of dollars to shell out for a medical opinion. If you run your own practice and you end up getting into this area, you can pay for a medical opinion if you have thousands of dollars. So once the VA provides that exam and you've satisfied that threshold determination, you know, the indication that something may be related, et cetera, and the VA goes out and gets that exam, the exam has to be adequate. And this is where we do a lot of litigation, is whether the VA exam is adequate. Are we gonna talk about reasons why? No. Okay, I'm gonna talk about, real quick, a few reasons why an exam would be inadequate. It's based on an inaccurate factual premise, which happens more often than you would like to think. For example, I had a case, a Vietnam veteran, who I think was a cook. So it's what Dave was saying, but he said, you know, really horrible things happened to his unit while they were in Vietnam, and that he now has diagnosis of PTSD. So all of his VHA treating providers, right, have diagnosed him with PTSD and have related it to his experiences in Vietnam. But VA, once he files for benefits, sends him to a VBA examiner who says, no diagnosis of PTSD. In fact, I don't think he even has a mental problem at all. And the reason why is because he only started complaining of these symptoms after he filed his claim. But then if you look through his records, he's been medicated since 1989 for anxiety. And so I could go to court and prove this is an inaccurate factual premise, that his records show that he's been medicated by his primary care physician for anxiety since 1989. Now that exam is out, it's totally out. And in that case, I actually brought it to court, and VA General Counsel settled, meaning that they didn't just agree to a remand, they agreed to grant him service connection and pay him benefits. So that's one thing that you might find. Sorry, I'm 5 months pregnant and this baby takes all of my oxygen and I can't even breathe. So that's why I'm panting, not because I'm so excited for inadequate exams. But another thing we see a lot is inadequate rationale. So there has to be some rationale accompanying the medical opinion. The doctor just can't say, nope, not related to service, period, the end. Now, the doctor doesn't have to provide 30 pages of explanation as to why it's not related, but there has to be something that the board and the court and the veteran can look at and say, oh, okay, that makes sense. If there isn't anything at all, that's a good case. But sometimes, for example, I have a case I'm working on where the guy is service connected for diabetes due to Agent Orange exposure and has an occlusion in his eye, which not really clear on what that is, doesn't matter, I'm a lawyer, not a doctor. All I know is that there's some indication that the diabetes may play some role in the retinal artery occlusion. So VA rightly asked an examiner, did diabetes cause or aggravate this occlusion? Because that's two ways you can get service connection. And the doctor says no, because it did not cause or aggravate the occlusion because diabetes was diagnosed many years prior to the occlusion. Okay, well that tells me how we know, right? Or no, the occlusion was diagnosed many years prior to diabetes. So that tells me that diabetes didn't cause the occlusion, right? How could it cause the occlusion if the occlusion was diagnosed many years before diabetes? But that doesn't tell me that the diabetes didn't make it worse or explain to me how it's impossible that the diabetes made it worse, right? So that's an inadequate rationale. And one of my other favorites is talking about Agent Orange. There's a list of diseases that VA presumes to have been caused by Agent Orange exposure. And if you have one of those diseases and you're a Vietnam veteran who stepped foot on the land of Vietnam or the inland waterways, then you don't need a medical opinion. The law steps in to provide the medical opinion, in essence. But what if you are a Vietnam veteran and you have a disease that's not on the list? Well, you can still get service connection, but you need that medical opinion. So oftentimes, VA will rightly send the veteran to a VA examiner for an opinion, and the doctor will say, no, not related to Vietnam or to Agent Orange exposure because it's not on the list of presumptive diagnoses. And that doesn't make any sense, right? That's the doctor saying, you can't get service connection because we won't presume service connection. Or there can't be a medical link because the law doesn't presume a medical link. That's inadequate. So there are some examples. So if you get this case, what time do I go to?
4:30, don't you want to have questions?
Okay. So if you get a case that before it gets to the Board of Veterans Appeals, remember the different levels. You have the regional office, file your notice of disagreement, you get your statement of the case, then you have to perfect the appeal by taking the second step of the substantive appeal, and then it goes to the board. So if you get this case before it gets to the board, and you see that there is an exam, there should be an exam, or that the exam is inadequate, you can tell the regional office, look, this exam is no good, you gotta get another exam. Same thing if you get to the board. You can say, look, the regional office should have gotten an exam here, this is how these elements are met, or this exam is inadequate, this rationale is no good, or there's an inaccurate factual premise. And if it's at the board will remand to the VA, which the board does in well over, or will remand to the regional office, which according to the board chairman's report, the board does in well over 50, I shouldn't say well, about 50% of their cases. which is a really high number if you think about that. If you get to the court, and you can argue that, the court will vacate, and you're right, the court will vacate and remand the board's decision, and then at that point you can submit additional evidence. So you can't submit additional evidence to the court, but if you win in court and get it back to the board, you can.
Tell them what percent of
I don't know. Yeah, I don't know precisely. I know that the overall reversal, remand, vacate rate is somewhere around like 70-something%, which that includes not only decisions that the judges make, but like the vast majority of NVLSP's cases are resolved by the VA saying, yeah, you know what, you're right, we screwed this one up. Let's file a motion asking the court to vacate and remand the case. Over 70% of cases. Now, you know, the court doesn't see every single decision that the VA ever makes, and they only see the denials, right? And only a certain percent of those denials. But that's a pretty high error rate in any court. Okay, so now we're going to talk about the reasons or bases requirement. This only applies to the board. So the reasons or bases requirement is a statute that says that the Board of Veterans' Appeals has to provide its reasons or bases for its decision on all material findings of fact and conclusions of law. But the regional office has no such requirement. So Amelia, if she doesn't precisely lay out the reasons for the decision, it's not a legal error. I mean, you can continue the appeal and continue to pursue your theory of the case, but you can't say, but she didn't tell me what she thought about this medical record, so it's got to go back. That won't work. Only the board has that obligation, and the court has said it so that the court can conduct judicial review of the board's findings, right? So if the board didn't make a finding, there's nothing to review. So it has to go back for them to make that finding in the first instance. And it's also supposed to be to allow the veteran to understand the precise bases for the denial. Now, as an advocate, my opinion is that the court is way too literal with this reasons or bases requirement. As Dave said, you're much more likely to get a remand on this basis than you are a reversal. To give you an example of how literal they take that, we had a case where there were two medical opinions, a favorable one from a private examiner and an unfavorable one from a VA examiner. We took it to court and the board said that the unfavorable exam was better than the favorable exam in terms of its reasoning and its factual premises, and therefore it outweighed the favorable opinion, deny the claim. So we took it to court and we said that's all wrong. The unfavorable exam is actually speculative and didn't provide an equivocal opinion, and the favorable exam did, and it was based on all the information it needed to be based on and provided an adequate rationale. So in reality, the favorable exam was worth more probative weight and should have been followed by the board. And the Court of Appeals for Veterans Claims judge agreed with us and said, you know what, you're absolutely right. Their findings regarding the unfavorable exam were incorrect, and their findings regarding the favorable exam are correct. So what is the logical outcome? Reversal, right? Then the evidence actually weighs in favor of granting the claim. There's no other way to look at it. Court said, because these findings are incorrect, we need to send it back for the board to make the correct findings. I mean, that's how literal they take that. Now, the good news is usually if you get a case like that, once it gets back to the board, they'll grant it. But the bad news is, once it gets back to the board can get another medical opinion. And what if that medical opinion is unfavorable? And it is better than the favorable opinion, then they can deny the claim, and there's nothing you can do about it. So we actually took that to the Federal Circuit and argued that we had a right to reversal. The Federal Circuit said no. So some other reasons or bases errors we find is what we call the Colvin violation. So Colvin was an early CAVC case. So when I say early, about what date do you think it was? Early 1900s? Maybe we're gonna go real back in early 1800s? No, 1991. Because that's how young this court is. So the Colvin case is when the court said the Board of Veterans Appeals, who are not anymore made up of any doctors, they're all just lawyers like you and me, they can't make medical conclusions. So the board can't say, yeah, I see that this veteran was in Vietnam and was probably exposed to some combat stressors, but he doesn't meet the DSM-4 or DSM-5 criteria for a diagnosis of PTSD. That's a medical conclusion. Only a trained psychiatrist or other mental health professional can apply the criteria for a diagnosis of PTSD. I can't do it. I mean, I probably could, but no. I kind of do diagnose everybody I know. But according to the law, the board has to have a medical opinion in order to make a conclusion like that. But where do you draw that line? I mean, there are a lot of gray areas. Let me think of a case real quick. Okay, I can't. But you can think of some gray areas where it's unclear whether it's really a medical conclusion or a factual conclusion. Or another one was, we had a case where I think it was the eye occlusion again, and the board denied service connection, said, that's not an actual disability. That's just like a finding, that's just a symptom. And we took that to court and said, first of all, that's legally incorrect. And second of all, that's a Colvin violation. You don't know. I mean, what is your medical science to back up that particular conclusion? And then that was another one where the general counsel ended up settling with us and just granted service connection. Another thing they have to do is explain why unfavorable evidence is more probative than favorable evidence. And that goes back to the case that we took to the Federal Circuit, where we argued just this, that their reasons for saying why the unfavorable opinion was better than the favorable opinion were wrong. And the court agreed with us, but still sent it back, still remanded it, so that the board could make better findings. This is a big one that's been going on for a long time and still going on, is the board's treatment of lay evidence. Which, by the way, if you have a case like this at the agency level before it gets to the board, and you see that the rating decision includes medical conclusions that are not supported by anything in the record, you can raise these issues here. Or if the rating decision says that your private opinion that you submitted is wrong, or if they just ignore it, you can argue there, like, hey, what about this private opinion? Like, you shouldn't save these types of things for if you're going to court, but in terms of whether the failure to explain something is legal error, it's not until you get to the board. So lay evidence is a big deal, and lay evidence has to be considered at the board level and the regional office level. And lay evidence plays a really big role in veterans benefits law, because you just heard Dr. Oki say today, the veterans that she followed up with massive, severe TBIs, never registered with the VA or sought continuing care. A lot of veterans don't. And now think about that in the context of like a knee injury or a back problem. You know, it's unlikely that a veteran or even a lay person is going to go crying to the doctor every time you have a little knee or back pain. You probably just take a Motrin and deal with it, right? And what's more is a lot of veterans either are unaware or don't have access to VA care because of they don't meet the service connection requirements, or I don't profess to be an expert in the different levels of priority for VA care, but not every veteran is eligible for it. And if that veteran is uninsured on top of it, it's really unlikely that there's going to be records, treatment records of continuous care. And in those cases, the only evidence that you can have demonstrating that a veteran had continuing problems after service is his or her own statements. So for a long time, VA, Amelia, close your eyes. I mean your ears. Your ears. So from my own personal opinion, and I think that, you know, it can't be proven, but I think that you can kind of see this, is that for a long time, VA has come from a place of people lie, and people do lie, but VA adjudicators sometimes are really wary of the lies and are extra vigilant to make sure that people who are lying do not get granted benefits, because they do have a duty to protect the public fisc. The problem is that a lot of veterans who are not lying fall victim to that hypervigilance. I heard a judge at the CAVC say once that it's like an adjudicator gets burned once and then wants to make sure that he or she is never burned again. But again, the problem is a lot of people who are not lying and who are really suffering get caught in that trap. So lay evidence especially is where this becomes a problem. And for a long time, VA would say, either not consider lay evidence at all, or say, no, it's not credible because there's no contemporaneous record of treatment. And in 2007, Federal Circuit put an end to that. Said you can't do that anymore. I mean, the VA can consider the lack of contemporaneous treatment as a factor in determining whether a veteran's statements are credible, but that can't be the only thing. Sometimes I see in board decisions, well, there's no contemporaneous record of treatment, and this veteran is self-interested and biased because if we were to accept these statements as true, we would have to grant benefits. Well, no kidding. Using that line of logic, every veteran who applies for service connection is self-interested and biased and a liar, right? So the law has recently made a trend towards making it harder for VA to reject lay evidence. And a place that we saw this recently that was a really big deal was in military sexual trauma, a case called AZ versus Shinseki. God, I really can't breathe. It went all the way up to the Federal Circuit. Now, VA has a special rule in place dealing with MST that says that it doesn't have to be documented in the service records, and that lay evidence and other records can be accepted. So like police reports or transfer records, evidence of drug use or other behavioral changes after the alleged incident. That's what the rule says. But in practice for a very long time, and I must say, like I said earlier, VA is really good at responding to publicity, and recently has become much, much better at handling these claims. But for a long time, it didn't really matter. If it wasn't in the service records, the VA would say it didn't happen. And AZ versus Shinseki involved 2 companion cases to women service member veterans who filed claims for PTSD or another mental health disability based on sexual trauma that occurred in the military. And I think they had their lay statements, but they didn't really have any records. Like they didn't see, there's no police report because it wasn't reported. There wasn't really any out of the ordinary STD testing or anything like that in the records. But they had like their families and their friends from around the time be like, yeah, like things are really bad for her. One of the women had a family member who said, she told me about this, in 1989. And it got up to the Court of Appeals for Veterans Claims, went before 2 male judges who said the board was absolutely correct to reject that testimony is not credible because there's nothing about it documented in the records. So the lawyers, very smart lawyers in charge of, it wasn't me, but very smart lawyers in charge of those cases brought it up to the Federal Circuit, who wrote this really excellent opinion that talks about how everybody knows, it's no secret, that military sexual trauma is not generally reported, right? So victims of sexual trauma don't usually report it. And so then, even though the rules, federal rules of evidence don't apply to VA adjudications, so they can be used as guidance. And the Federal Circuit looked to the federal rules of evidence and said, it's basic, the basic underlying premise is that if you wouldn't expect to find something in a certain place, then you can't use the absence of that thing as substantive negative evidence. So that translates to, because military sexual trauma is generally not reported, you can't use the absence of any documentation of that in the record as substantive negative evidence to now say that these lay statements are not credible. And I mean, it took us, this was like 4 years ago. It took us that long to get to this point, and something that's so obvious like that. But anyway, so I just went off a little bit on military sexual trauma. But that's a little bit of background about how the law has changed in dealing with lay evidence. Another big issue is the board's failure to discuss and consider all issues reasonably raised by the record. We don't really have to get into that, except to say, we talked a little bit earlier about the doctrine of exhaustion of administrative remedies. And it's true that it does exist in veterans law with the courts, but the courts have really picked and chosen what is an issue that has to be exhausted and what's not. So no, the competency of an examiner has to be exhausted. Thanks to Scott, that Dave was just talking about, we know that procedural issues like failure to grant a hearing have to be raised at the agency if you want to take it to court. And there are like 2 or 3 other little side issues. But other than that, it's all fair game. As long as something has reasonably been raised by the record, the VA has to consider it. So let's take an example that we see a lot, is a Gulf War veteran who complains of joint pain, like in the knees and the back. And the veteran is sent to the exam. The examiner says, I don't see any pathology to explain this pain. So therefore, there's no diagnosis. Well, you have to have a diagnosis, right, to get service connection, because you have to have a current disability. And pain alone, under the current law, is usually not a disability, except if you're a Gulf War veteran, because Congress has acknowledged that Gulf War veterans, and that includes up to today, serving in Southwest Asia, except possibly Afghanistan, but that's a whole nother symposium, have been exposed to environmental hazards that we're not really even sure what they were, and that these folks came back from Southwest Asia with symptoms that couldn't really be attributed to a known clinical diagnosis. And once again, Congress has provided that if you are a Gulf War veteran and you meet this criteria of having these symptoms that can't be attributed to a known diagnosed or a known clinical diagnosis, then the law will step in to presume that those symptoms are related to your service in the Gulf and whatever you were exposed to over there. Now, Amelia, close your ears again. VA hates this law, right? And it kind of goes back to how easy is it to just say, well, my elbow hurts, and there's no way to actually objectively prove that. Not only do they usually not do a very good job of adjudicating it, but if the veteran doesn't specifically raise it, they don't adjudicate it at all. So let's go back to our veteran with the back and the knee pain, goes to the exam, doesn't have a diagnosis. If that's Gulf War veteran, then ding, 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 that automatically raises the issue of an undiagnosed illness. But we've had a really good run of cases that come up with just that fact pattern. The board never mentions the Gulf War syndrome statute and regulation. We take it to the court, and the court will say, yep, you know, they should have discussed this, even though the veteran never raised it herself, because the veteran's theory is not, the board isn't limited to the theory of service connection that the veteran herself has put forth, because she's, first of all, not a doctor, and second of all, not a lawyer, and not expected to have any kind of expertise in the medical or legal realm. So medical opinions, we kind of talked about, and I'm going to rush through this so we can get to questions. Talk about rationale. Oh, another thing is, board can't reject a medical opinion that's based just on what, or in the VA, the regional office can't do this either. That's based just on what the veteran told the doctor, unless the VA can point to something in the claims file and say, this contradicts what you told your doctor. So again, if the vet told the doctor, oh man, and then like I was involved in like this big huge explosion, and I like broke my knee and I was in the hospital for 7 weeks, and then you can look at the service medical records and see that that never happened, then they can totally reject that. But if the veteran goes in and says, you know, we had to do a lot of marching with really heavy packs, and I had knee problems ever since that, the VA can't reject a favorable opinion based on those facts unless they can say that that's not credible. And they can't say it's not credible just because there's no documentation of treatment, right? We just talked about all that lay evidence. So, you know, this is all kind of elementary stuff. If the VA can't violate statutes, they can't misapply the law. And usually the cases that we see at court, the majority of them are not really these novel, complex issues of law. They're really just a dispute on the facts. The board found this, but actually the record shows that kind of thing. When you do get like a case that has a cool legal issue, that's exciting. Oh yeah, so we talked about how these cases go up and down and up and down and up and down. I had a case I just finished briefing where the veteran filed the claim in 1991. It's been going up and down and up and down for what is that, 25 years almost? No, 91? Yeah. So, I mean, that gives you, now that's not my everyday case, but they do exist out there. So in that 24-year period of time, there have been a lot of orders from the board remanding the case back to the regional office for an exam or to get records or something like that. Now, my client had a right to the RO's regional office's compliance with each of those remand orders. So if the board were to send it back and say, get an exam that says X, Y, and Z, and they got an exam that only said X, then that would be a remandable error.
I'm leaving, Amy, so you gotta quit talking.
Okay. Really?
Really, you need to sit
Okay.
around 4:30, and I want people to ask you questions, and Amelia,
Okay,
and Dave.
so that's it. Yeah. So if you want to know more, the Veterans Benefits Manual is available on our website, www.nvlsb.org.
Can we ask for an autographed copy?
You might want to wait until the 2015 version comes out. It'll be available next month, and it will have my name on it. It is out? Why don't I have a copy? Yeah, where's mine?
So, Chris is done, has a question, yell it out, Chris.
What if the operation where the exposure to bad things occurred is still classified? How do you get bloody letters? What do you do?
It depends on what you're talking about.
Borreliosis.
I'm sorry?
Borreliosis?
Oh, so like a tropical disease?
No. Exposure to special weapons materials?
Okay, so you're not talking about any presumptions of service connection, like we were talking about Vietnam and Gulf War? Okay.
Nuclear deterrent.
So I know that the VA, and maybe you're better to answer this, Amelia, but doesn't the VA have like special people at the RO who deal with the Joint Services Research and Records Center on classified records?
Yes, yes. We, the VA, I don't know, is this on? Hello?
Yeah.
The VA does have records specialists. They have people that are trained to investigate incidents such as this. There is a Joint Services Records Research Center, as Amy just said, JSRRC, that also has their own authority and is able to research records that we can't get our hands on. So there is a level of research that goes into trying to verify incidents, exposures, jobs, missions that are classified. And a lot of times as well, I find that the veteran thinks they're classified and they're not. So in that kind of case, I'd say apply anyway, let us do our thing. Maybe it's not classified, even if it is, maybe we'll be able to get our hands on
Okay,
the evidence.
The VA doesn't have the records the Chinese do, right?
Well, what I was gonna actually say is that if it's not classified, it's probably available to the public from the National Archives. And so my case that I just talked about, that we got the win from the CAVC with the 60-day window, that had to do with the Joint Services Research and Records Center. And my research indicated that the JSRC can sometimes be an unreliable source. So as an advocate, if I were you, I would put the time and effort into it to do the research, to contact the National Archives, see if you can get the records yourself and submit them.
And there's always Google.
Yeah.
Yeah, you want to go ahead and apply for that because they can deny it, but you can go back and say that they're Department of Defense records, and then it'll fall under regulation that will allow him to get that original effective date, even if he doesn't file an appeal. So
Yeah.
he reopens it later when those records are found.
Yeah, actually, I have a case now that I'm dealing with, to put that in perspective, that had to deal with testing some nasty stuff at the Aberdeen Proving Ground. And those records were classified for a really long time. And my veteran applied for benefits when he first got out, like in the 70s. And they were just declassified, I want to say within the last 10 years. And so because he applied when he just got out in the 70s, and those records existed, but they couldn't get them, his effective date for benefits could potentially go all the way back to the 70s now, because they declassified the records.
They were in the constructive custody of the federal government,
That's right.
and we didn't get them back then. We got them then.
Yeah, I wonder if Amy and David could tell me what percentage of the vets that end up before the Board of Veteran Appeals are unrepresented? Because I'm a little worried about, I feel like the cycle of the vet just getting thrown back after the remand, even though you call it victory because the ball's in the air. But now they're back before the Board of Veteran Appeals. Some of the great lawyers that you got to do pro bono in the Court of Veteran Claims are not there anymore. So I wonder if we're just throwing them back into a situation.
No, nobody gets thrown anywhere. Here's the situation, circumstances. First of all, a lot of our people, about 40 or 50%, let's leave it closer to 40, stay with the case. And if you stay with a pro bono case going back on remand or up to the federal circuit, we continue to provide support. You get a new Bible every year, and our folks are available for questioning. If the attorney cannot continue, we take a look at the case, and we're just kind of trying to figure out how to do this without offending the service organizations. And we're working with the folks, DAV and the American Legion, PVA. Most of these people have had a service organization, and quite frankly, what the service organization wants us to do is to return, if if not represented, they want us to get the vet, the appellant, back to their service organizations. That works a whole lot of the time, but we're still kind of awkward as to how we're doing it. Some of it's, we call the service officer up and say, hey, we got one of your clients, or we'll talk to Roy Spicer, DAV, or the Legion rep, or whatever. The two problem children are, one, if they didn't have a service officer when they got to the court, and that does happen. And quite frankly, right now, we have got representation at the notice of appeal is down to about 23%, 23, 25, 26%, which is a lot lower than it used to be. If they were not represented, we're trying to figure out exactly how to do that, because the service organizations, it's in a state of flux. Everybody wants to help, we're just not quite how sure to get it done. The other case is occasionally it comes up where the veteran does not like his original service officer for whatever reason. And again, it's in a state of flux. We're trying to make it happen, but nobody gets thrown back out there. If they want help, we try to figure out how to do it. So I'm looking at the lights. Does that answer your question? Who asked the question? Hi, good to see you. Literally.
No, I think, it's careful, you have to be careful to differentiate between, if you say represented in the veterans law world, that will also, people will think about veterans who are represented by counsel and veterans who are represented by veteran service organizations. And if you think about it in those terms, then it's close to 90% are represented at the board, but it's probably closer to 20% if you're talking about lawyers. And don't quote me on that. And if you're really, really interested and want to know the statistics, the board puts out a fiscal year report every year. 2014 just came out, and it has those numbers. Any other questions?
Both of us